Okay, good morning, ladies and gentlemen. I just would like to thank Ms. Justice Lafoy for inviting me here to speak to you today. And my role is to talk to you about international human rights law and what international human rights law has to say to Ireland and has to say about Ireland's laws in relation to abortion and in relation to fatal fetal abnormalities. Just to give you a quick overview of what I'll be looking at. I'm going to start with this idea of the sources of law, because I know in the last session of the Assembly and even this morning we have been looking at legislation and case law and then looking at the European Convention on Human Rights, and it really is important to understand the relationship between all of those sources and to see how important they are in the Irish legal system, to understand fully what obligations are on the Irish government in relation to this question. So when we're looking at international human rights law, we're going to look at laws that are not made in Ireland. So we're not looking at Irish legislation, or we're not looking at the Constitution, but we're going to look at instruments that have a human rights focus that were created by international institutions or organisations, including the United Nations and the European Union and the Council of Europe. So in particular, we're going to be focusing on the Charter of Fundamental Rights, which was created and adopted by the European Union. And we're also going to be looking at the European Convention on Human Rights, which was referred to in Eileen's discussion about the A, B and C case. And the final piece of legislation we're going to be looking at is the International Covenant on Civil and Political Rights, which was adopted by the United Nations and is of great relevance in relation to the Mellet case just mentioned earlier. So these are our sources of law in Ireland, and I know that over the past two sessions of the Assembly you've been looking and focusing really on Irish law. So you've been looking at the Irish Constitution, Irish legislation, for example, in relation to the Pregnancy Act, and also common law, so when we're looking at judgments from different cases in different courts in Ireland. But we also have a fourth source, a primary source of law in Ireland, which is the law of the European Union. And the European Union law is actually supreme over Irish law. So any acts or any pieces of law that are coming from the European Union, they actually trump the Irish Constitution and trump legislation. So when we're looking at this, we have to see, well, what does the European Union law say about this, and how can we be guided by it in making any decision in relation to this question? As well as these four primary sources of law in Ireland, we have a number of what we call secondary sources. Now, these secondary sources don't bind Ireland per se. They don't have the binding force of law. But what we call them, we say they have a persuasive value. So when a judge is looking at a particular case and trying to decide a particular legal question, they can refer to an international treaty, an international legal principle, and they can find guidance in that, and they can find information as to how to come to an answer to this legal question. They don't have to, they have the choice. So what we say is that international law is of persuasive value when deciding any legal question. And that's important when we come to the Mellet case, which has been mentioned earlier and which I'll get onto in a little bit more depth in a couple of minutes. But to start off with European Union law. So European Union law, as I said, is supreme in Ireland, so has a primacy over the legislation and the Constitution. We have in European law what we call the Charter of Fundamental Rights, and this came into force in 2009. And for human rights lawyers, it is an example of one of the best human rights treaties that has ever been adopted, because it is so broad and all-embracing in the types of human rights it protects. So this is part of European Union law. And as it is part of European Union law, it also has precedence over Irish law when it comes to issues of human rights and questions of human rights. The issue about the Charter, however, is that it's limited in scope. So it only applies if there is a question of European Union law being implemented in Ireland. So when a question of European Union law arises, well, then the Charter can kick in. It can kind of be considered. Does this piece of European Union law, is it in line with all of these rights that are protected in the Charter of Fundamental Rights? So that's one of the limitations of it. So it doesn't have overall scope. It's not going to apply all the time. It only applies when there's an issue of European Union law arising. However, when there is an issue of European Union law arising, and when the Charter does apply, it is directly applicable by Irish courts. Now, what I mean by that is that an individual in Ireland can base their claim on the Charter of Fundamental Rights and can go to an Irish court, look at the Charter of Fundamental Rights and say, right, look at this particular provision here. If it has an issue to do with abortion, this particular Charter of Fundamental Rights deals with issues like the right to healthcare. So that might be, a relevant right that an individual could bring up in an Irish court. And if they do, then it is directly applicable and Irish judges will apply it. And it also has precedence over domestic law if there is a conflict between the two. And as well as that, we have a court. So we have the European Court of Justice, or the Court of Justice of the European Union, as it's also termed. And this court applies the Charter also. So an individual, if there is a case in relation to European Union law and the Charter is brought up, an Irish court has a right to actually refer a decision over to the Court of Justice. They can say, right, there's a question of European Union law here, we're going to refer it over, and we're going to get guidance from this Court of Justice on this particular issue. So in that way, we might have to kind of be open to interpretations of the Charter from a non-Irish court in this regard. And the decisions of the Court of Justice are binding on Ireland. So the Charter of Fundamental Rights itself is silent, as are all international human rights instruments, on the question of abortion. But they do contain provisions which might be of relevance if a case were to be taken on this issue, including the right to health care, or the prohibition on torture and cruel, inhuman and degrading treatment, or the right to privacy, which are rights that are often triggered when this question arises. But this Charter hasn't really come up in a case in relation to the Charter of Fundamental Rights concerning abortion in Ireland to date. But now we're going to turn to international law. So this is our secondary sources of law. And there is a huge difference between EU law and international law, because EU law is binding on Ireland and international law is only a secondary source. And we're going to look at two particular instruments when we look at this idea of international law. And the first is the European Convention on Human Rights, which has been referred to a couple of times and came up in the case of A, B, and C in Ireland. And the second is the International Covenant on Civil and Political Rights, which came up in the situation of Mellet in Ireland. Now, if we look at our Irish Constitution, it tells us that Ireland can enter into international treaties. So they can take a treaty from the United Nations, and the United Nations produces numerous human rights treaties. So they have conventions on the rights of the child, they have convention in relation to the rights of people with disabilities, and they also have this convention or this covenant on international civil and political rights. So Ireland can choose to sign up to these treaties, or what we ratify these treaties. Now, if Ireland ratifies these treaties, that doesn't make that international instrument part of our domestic law, which is an issue. What we have to do is the Oireachtas has to normally pass a piece of legislation to incorporate it into our domestic legal system. So Ireland has ratified a number of international instruments, but it hasn't incorporated them into the domestic legal system yet, or it may never do so. And there is the question of, well, what is the status of that international instrument? And can a person rely on that instrument in court? So we have two examples here. So the first one is the European Convention on Human Rights. Now, in 2003, Ireland incorporated this indirectly into our legal system by means of the European Convention on Human Rights Act 2003. Now, what this means is that Irish courts are required to interpret any rule of domestic law, so any Irish legislation, any provision of the Constitution. Irish courts must interpret them in line with the state's obligation under the Convention. So we have this extra layer that we have to check the compatibility of Irish law with. So we have to look at our Constitution and say, right, is this in line with the rights that are protected by the European Convention on Human Rights? Section 4 of this Act also requires that Irish courts take into account or take into consideration any judgments from the European Court of Human Rights when they are making decisions. Now, if an Irish court finds that Irish law is in fact incompatible or not in line with the rights that are protected and promoted in the European Convention on Human Rights, what they can do is issue what they call a declaration of incompatibility. Now, that doesn't mean that that piece of Irish law, that provision of the Constitution, or that piece of legislation is null and void. It means that the Taoiseach has to go and lay before the Houses of the Oireachtas this issue, that this has come up, and then they will decide a way forward from there. And the individual whose rights have been adjudged to have been violated can get compensation at the discretion of the Taoiseach in that particular case. The European Court of Human Rights is the guardian of the Convention. So this is the court that kind of implements the Convention and makes sure that the rights that are set out in the Convention are protected by states. So as well as Irish courts dealing with the European Convention on Human Rights via the European Convention on Human Rights Act, you also have this other court, the European Court of Human Rights. And if an individual feels that the rights that are protected under the European Convention on Human Rights have been violated by the state, they can take a case to this particular court. Now, as Eileen explained, they can only do this after they've exhausted domestic remedies. So after they have appealed all the way up through the Irish court system, normally that is the position that they then can go over to the European Court of Human Rights, unless there is no chance of success. Which is called the exhaustion of domestic remedies, as I mentioned. Again, states are obliged to abide by judgments of this court. So in the case of A, B, and C, we found that the court found that Miss C's rights to privacy had been violated by the state. And in that case, they required the state to act and to, look at their legislation and, to make a move, and which they did. They adopted legislation on this particular issue. So these decisions are binding on Ireland. So we have to look to what the cases and the case law and the decisions of the European Court of Human Rights are when we're looking at, what is the law on this issue in Ireland. We're in a slightly different position when it comes to the International Covenant on Civil and Political Rights. Now, this instrument was adopted by the United Nations, so it's a fully international treaty, not regional as in the sense of the European Convention on Human Rights. So every state in the world has the option to sign up to or ratify this particular covenant. So Ireland has ratified it. We have signed up to it. So we have said, we're going to be bound by this particular treaty, but they haven't incorporated it into their domestic law, and this is a huge issue. Because people are wondering, what's the status of any decisions that come out of the body that is the monitor of this, which is called the Human Rights Committee. So as well as the covenant, we have what's called an optional protocol to the covenant. And again, these are very technical terms, but what this basically means is that it allows individuals within a state to make a complaint to an adjudicative body as part of the United Nations, which in this case is called the Human Rights Committee. Now, you'll see from the name, it isn't a court. So it's a semi-judicial body is what it is often called. The people who sit on it are 18 human rights experts. So they may not even be lawyers. They may not have an understanding or an appreciation of finer legal issues. They may not be legally trained, but they have an expertise in human rights. And if an individual, again, exhausts domestic remedies, so appeals their particular case all the way up through the court system in Ireland, they can make a complaint to this committee. This committee, under Article 2, Paragraph 3 of the Covenant, this particular article requires states to provide victims of violations of the Covenant with an effective remedy and reparations. That's the language of the instrument. It's not telling you that these decisions are binding on the state, but it's telling you that the state has to give some sort of reparation. So this has always been an issue in relation to the Irish government, and there's always been a question as to what is the status or what is the standing of anything that the committee actually says. And this came up hugely in the case of Mellet in Ireland. And Miss Mellet had found out in 2011, when she was 21 weeks pregnant, she learned that her pregnancy involved a fetal abnormality. She was told that the fetus would die in utero or shortly after birth, and she had decided to end the pregnancy. She was told at the hospital that she could not access abortion services in Ireland, and she decided that she would go to the United Kingdom, which she did, in order to obtain an abortion. So she used her own finances and flew over to England with her partner. But because of a lack of finances, she had to fly home again 12 hours after the procedure. When she flew home, she was very, very weak and still bleeding. 2 years later, the Centre for Reproductive Rights filed a complaint on her behalf to the UN Human Rights Committee. And the Human Rights Committee found that Ireland had violated a number of Miss Mellet's rights. They found that Ireland had violated Article 7, which looked at the right to be free from cruel, inhuman or degrading treatment. They looked at Article 17, which protected Miss Mellet's right to privacy. And they also said that Ireland had violated Article 26 of the Covenant, which is the right to equality before the law. In this case, they looked at the fact that women who had suffered miscarriages would have got access to counselling care in Ireland. And in relation to Miss Mellet's case, she got no continuity of care and she got no offer of counselling after she came back to Ireland. So these decisions were made in June of this year. The committee highlighted to Ireland that Ireland had to make some form of reparation to Miss Mellet because she was a victim of human rights violations. And then in November, the minister, the state via the minister, offered Miss Mellet a sum of €30,000, as well as a requirement that she should be allowed to access the appropriate psychological treatment. One of the other recommendations of the committee was that Ireland reform its abortion laws in order that other women would not suffer similar human rights violations in the future. And in response to that particular situation, the state said, well, the Citizens' Assembly is looking at this issue, and that's all they said, that it's being dealt with, and that we're looking to review it at the moment. So to conclude, if you look at international human rights instruments, they have a very important part to play in the Irish legal system. Some, like the Charter of Fundamental Rights of the European Union, has precedence over Irish law. Others, such as the International Covenant on Civil and Political Rights, is a secondary source, but yet the Irish government or the Irish state has to act in response to decisions made by this particular body. However, none of these human rights instruments refer to abortion as such and leave a lot of choice up to a particular state how they deal with this particular issue. However, a number of rights in these charters and these instruments, such as the right to healthcare, the right to privacy, the right to freedom from torture and cruel, inhuman and degrading treatment, all of these rights are in these particular instruments, which must be taken into consideration when we look at any law in relation to this particular question in Ireland. Thank you.